If you are an Indian investor trying to get a U.S. green card through the EB-5 program, stop what you are doing and watch this video right now. The U.S. Department of State has just released the May 2026 Visa Bulletin, and it contains a serious warning specifically for Indian EB-5 applicants. Numbers could run out, dates could move backward, and if you miss your window, you could lose your place in line. This is not something you want to miss. Welcome back to Immigration Radar USA, your trusted source for clear, accurate, and up-to-date U.S. immigration news. I'm your host, and today we are breaking down the May 2026 Visa Bulletin, released on April 15, 2026 by the U.S. Department of State. Every single month, the State Department publishes what's called a Visa Bulletin. This bulletin tells immigrants, investors, and families when they can apply for or receive their green card based on their visa category and country of birth. Think of it as a queue system. It tells you where you stand in line. Today, we are focusing specifically on one category that is making headlines, EB-5, the Immigrant Investor Program, and what the May 2026 Bulletin means for applicants born in India. The information in today's video comes directly from the official May 2026 Visa Bulletin published by the U.S. Department of State and reporting from immigration legal experts. We always bring you updates from verified official sources. No rumors, no speculation. So let's get into it. First, let's quickly explain what EB-5 is for those who are new here. The EB-5 visa is a pathway to a U.S. green card through investment. If you invest a qualifying amount of money, typically $800,000 in a targeted employment area or $1,050,000 elsewhere, and that investment creates at least 10 full-time U.S. jobs, you and your immediate family may be eligible for permanent residence in the United States. It is one of the most direct, fastest pathways to a green card, at least on paper, and it is especially popular among high-net-worth individuals from India. Now, there are two types of EB-5 visa numbers you need to understand. Number 1, EB-5 Unreserved. These are the general pool visa numbers. They are available to applicants from all countries, but the supply is limited, and high-demand countries like India and China can face backlogs. Number 2, EB-5 Reserved. These were created by the EB-5 Reform and Integrity Act of 2022. They set aside a fixed percentage of EB-5 visas for specific project types, rural areas, high unemployment areas, and infrastructure projects. These reserve numbers are separately counted and have historically been more available. Now, here is the big update from the May 2026 Visa Bulletin for EB-5 reserved categories. Good news first. All three reserved EB-5 categories, rural, high unemployment, and infrastructure, remain current for India in the May 2026 Bulletin. That means if your investment falls into one of these reserved categories, there is no wait. You can proceed with your green card application right now. This is a positive signal and something Indian investors should pay close attention to. For EB-5 Unreserved, this is where the warning comes in. The State Department has placed EB-5 Unreserved numbers for India under close monitoring in the May 2026 Bulletin. What does close monitoring mean? It means the government is watching how fast Indian applicants are using up the available EB-5 Unreserved visa numbers. And the concern is this: if demand from India continues at its current pace, the annual cap on these visa numbers could be exhausted before the end of Fiscal Year 2026, which runs through September 30th, 2026. If that happens, the State Department would have no choice but to take one of two actions: retrogression, meaning the final action date gets moved backward, pushing more applicants out of eligibility, or unavailability, meaning the category is simply closed for the rest of the fiscal year. This is not a hypothetical. This has happened before. In May 2025, Indian EB-5 unreserved dates were retrogressed by 6 months. The year before, there were similar disruptions. This cycle of retrogression has become a recurring pattern, and the May 2026 Bulletin is essentially an early warning signal that it could happen again. What are the current dates? Let's look at the numbers for India in the May 2026 Bulletin across employment-based categories. EB-1, Priority Workers, stuck at April 1st, 2023. EB-2, Advanced Degree Professionals, stuck at July 15th, 2014. EB-3, skilled workers, stuck at November 15, 2013, EB-5, unreserved, currently showing a date, but flagged for possible retrogression. EB-5 reserved, rural, high unemployment, infrastructure. Current, meaning no wait. These dates are called final action dates. Your priority date must be earlier than this date before USCIS can approve your green card. For EB-2 and EB-3 applicants, the backlog is measured in decades, over 10 years of waiting. These categories are, as immigration attorneys describe them, structurally frozen. Without an act of Congress, these dates are unlikely to move meaningfully forward anytime soon. So what does all of this actually mean for you, the Indian investor or green card applicant? Let's break it down into 3 groups. Group 1, Indian EB-5, investors in the unreserved category. If you have already filed or are planning to file under the EB-5 unreserved category, this warning should put you on high alert. The message from immigration attorneys right now is simple. File as quickly as possible. Here is why timing matters so much. When you file your adjustment of status application, Form I-485, you lock in what is called a priority date. That priority date secures your place in line. Even if retrogression happens after you file, USCIS will hold your case and process it once numbers become available again. But if you have not yet filed, and retrogression happens before you do, you could be locked out entirely until the next fiscal year, or until the dates move forward again. Beyond just the green card itself, filing early also gives you immediate access to important benefits. Work authorization, known as an employment authorization document, or EAD advance parole, permission to travel internationally while your green card is pending age-out protection for children. This is critical. If your child is approaching age 21, filing quickly can protect them from aging out of derivative beneficiary status. These benefits alone make early filing extremely valuable. Do not wait. Group 2, Indian EB-5 investors. Considering the reserved categories. Here is the silver lining in all of this. If you are planning an EB-5 investment and have not yet committed to a specific project type, now is the time to look seriously at reserved category projects, meaning rural, high unemployment, or infrastructure. Why? Because as of May 2026, these categories remain current for India. There is no backlog, there is no retrogression warning. This means a qualifying investor could potentially file for a green card without the long wait that plagues unreserved applicants. The EB-5 Reform Act created these set-asides specifically to encourage investment in certain parts of the U.S. economy. And for Indian investors, they represent one of the fastest lawful pathways to permanent residence available right now. Speak with a qualified immigration attorney who specializes in EB-5 to understand whether a reserved category project is right for your situation. Group 3, Indian EB-2, EB-3, and EB-1 applicants. We want to acknowledge you too, because we know that hundreds of thousands of Indian professionals are waiting in the employment-based queue. The May 2026 bulletin brings no good news for EB-2 and EB-3 applicants from India. The dates remain frozen. EB-2 at July 2014, EB-3 at November 2013. More than a decade of waiting, with no meaningful movement in sight. Immigration attorneys describe this backlog as structurally frozen, built over decades of high demand from India's large, highly educated workforce, combined with per-country caps that were designed when Indian immigration volumes were far lower. The hard truth is this: without congressional action, without a legislative fix to the per-country cap system, these dates are unlikely to move significantly. Bills have been proposed in the past, but none have passed. Until that changes, the best advice remains. File as early as you are eligible to lock in your priority date and secure ancillary benefits like work authorization. If you are in EB-1 or EB-2 national interest waiver territory, consult your attorney about whether your qualifications could give you a faster path. And for those who have been in the queue for years, we see you, we hear you, and we will continue to cover every development that could affect your case. One final important point on fiscal year timing. The U.S. immigration fiscal year runs from October 1 to September 30. We are currently in FY 2026, which ends September 30th, 2026. That means we have roughly 5.5 months left in this fiscal year. The State Department's warning about EB-5 unreserved numbers running out is specifically tied to this fiscal year window. If numbers get exhausted in the next few months, the category could be shut down for new filers until FY 2027 begins on October 1st, 2026. This is a narrow and closing window. Time is genuinely of the essence. Let's quickly recap what we covered today. The U.S. Department of State released the May 2026 Visa Bulletin on April 15, 2026. Here are the key takeaways for Indian applicants. 1. The EB-5 unreserved category for India has been placed under close monitoring with a warning that retrogression or unavailability could happen before the end of FY 2026. If you are in this category, file now, do not wait. 2. The EB-5 reserved categories, rural, high unemployment, and infrastructure, remain current for India with no backlog. This is the most accessible EB-5 pathway for Indian investors right now. 3. EB-1, EB-2, and EB-3 employment-based categories remain completely frozen for India with no forward movement in May 2026. 4. Family-sponsored categories saw some modest movement, with the F2A category jumping 6 months forward, a meaningful step for spouses and minor children of green card holders. 5. No matter your category, the advice is consistent. File as early as possible to lock in your priority date and protect yourself and your family. As always, we strongly recommend you work with a qualified, licensed U.S. immigration attorney before making any decisions. The information in this video is for educational purposes and is based on official government sources. But your individual situation requires personalized legal guidance. If you found this video helpful, please hit the like button. It helps more people find this information when they need it most. Drop your questions in the comments below, and we will do our best to address them. Thank you for watching Immigration Radar USA. Subscribe for the latest U.S. immigration updates, and we'll see you in the next one.